And the chair recognizes Ms. Kirkpatrick for the purpose of introducing our next witness.
Madam Chairwoman, thank you very much for this opportunity to introduce a fellow rancher from my great state of Arizona. My mother's family were ranchers in Navajo County, and we grew up knowing that healthy land makes healthy cattle, which makes healthy families. So I'm very pleased to introduce Mr. Jim Chilton, a fifth-generation rancher in Arizona. He is here to testify on behalf of the Arizona cattle growers, the Public Land Council, and the National Cattlemen's Beef Association. Along with his brother and family, Mr. Chilton ranches on 50,000 acres near Arivaca, Arizona. Like many ranches in Arizona, the family ranch includes private property, state school trust land, and federal land, a combination that presents unique challenges and responsibilities. Though his ranch is outside my congressional district, Mr. Chilton speaks today for many of my constituents. Thank you, Mr. Chilton, and I know the committee is interested in hearing your thoughts today. And thank you, Madam Chairwoman, for including ranchers as a critical part of our Small Business Committee.
Good afternoon, Madam Chairman, ranking member, and members of the committee, and thank you, Congresswoman Kirkpatrick. I am testifying on behalf of the Arizona Cattle Growers Association, the Public Lands Council, and the National Cattlemen's Beef Association, and my family. Protecting the quality of the nation's surface water continues to be a priority for livestock producers. As cattlemen, we have a commitment to being good stewards of the land, and that job we take very seriously. The Clean Water Restoration Act will negatively impact small business owners like me by limiting my ability to improve my ranching operations. The legislation vastly expands the Corps of Engineers and the Environmental Protection Agency's regulatory jurisdiction and will result in limitless control over all water in the nation and the dramatic expansion of bureaucracy. Ultimately, bureaucrats would control not only water, but citizens' lives and land use in all watersheds. The chairwoman mentioned that there are 15 to 20,000 existing 404 permits in the hopper waiting to be acted upon. Why add tens of thousands more? How many more bureaucrats will the Corps have to hire, or the EPA? As the Supreme Court has recognized, and my colleague Mr. Krause has indicated, it takes over 788 days and $271,596 to comply with the current process. And the average applicant for a nationwide Corps of Engineers permit currently spends 313 days with the average cost of $28,915. And as Mr. Krause pointed out, this is not counting the substantial cost for changes and mitigation. I'm quoting the Supreme Court in the Rapanos decision. Prior to the Supreme Court's Rapanos decision, I applied for a 404 permit to construct a normal dirt ranch road across a dry wash. I had to hire an attorney, environmental consultants, which cost about $40,000. Hearing of the costs in terms of civil penalties and et cetera, I decided to drop and abandon the project. We later abandoned another needed improvement that would require culverts in 2 dry washes on existing roads that have been there for 50 years on our private land. we were again told that we would need a 404 permit, even though the total impact would be slightly less than 1/10 of an acre in a 100-acre pasture. I ask, how can these two dry washes impact a navigable stream, since the nearest navigable stream is the Colorado River, about 275 miles away? The Clean Water Act of 1972 should not be expanded to include activities affecting water. What life activity does not affect water? It would open the door to lawsuits regarding every human use. The citizen suit provision would allow radical environmentalists to stop or seriously delay any farmer or rancher's improvement project anywhere in the nation due to the proposed expansion of jurisdiction. Another concern I have is the bias federal officer could have towards my livelihood, raising livestock. A rogue Corps officer could dilly, dally, and delay in approving a needed permit, or may demand over-the-top mitigation. The act must remain as it is and be limited to navigable waters as defined by the Supreme Court's Rapanos decision.